Hello and welcome to our quick revision series. Today we are discussing a modern digital age right that frequently makes headlines, the right to be forgotten. Imagine a past mistake or an old debt appearing on Google search forever, even decades later. This raises a central question. Does an individual have the right to scrub their digital footprint? This concept lies at the intersection of privacy, freedom of speech, and the right to information. In this session, we will examine its origin, its legal position in India under the Puttaswamy Judgment and the DPDP Act, and the challenges associated with its enforcement. To begin with, let's trace its origin. The right to be forgotten is not an Indian creation, rather, it emerged in Europe. In 2014, the Court of Justice of the European Union delivered the landmark Google Spain case, holding that individuals may request search engines to delink information that is inadequate, irrelevant, or no longer relevant. This principle was later formalized under the EU's GDPR, that is, General Data Protection Regulation. In essence, it allows individuals to ask a digital platform to forget them under specific circumstances, particularly when the data no longer serves a legitimate purpose. Now, does this right exist in India? The answer is yes, but it emerges through judicial interpretation rather than a dedicated statute. In the historic Justice K.S. Puttaswamy v. Union of India 2017 judgment, the Supreme Court recognized the right to privacy as a fundamental right under Article 21. Importantly, the court noted that the right to be forgotten is an integral component of informational privacy, giving individuals a degree of control over their digital presence. However, the court also emphasized that this right is not absolute and reasonable restrictions may apply in the interest of law, accountability, or public interest. This brings us to enforcement. Although India does not yet have a standalone law exclusively dedicated to this right, relevant provisions exist across different frameworks. The Digital Personal Data Protection Act 2023 includes the right to erasure, empowering users to request deletion of their personal data once its purpose is fulfilled. Additionally, the IT Rules 2021 require intermediaries like Google and Facebook to remove content violating privacy within 24 hours of receiving a valid complaint. However, applying these provisions to court records remains a significant grey area, particularly because such records are part of the public domain. The controversy around this right largely stems from a conflict between two fundamental rights. On one hand, the right to privacy under Article 21 protects an individual's dignity and autonomy. On the other hand, the right to information and freedom of speech under Article 19 ensure transparency and public accountability. This creates complex dilemmas. For instance, should a convicted corrupt official be allowed to erase news reports about their misconduct after completing their sentence? Similarly, removing court orders may conflict with the long-established principle of open justice. Courts today are trying to balance these competing interests on a case-by-case basis. Now, let's check your understanding with some quick practice questions. Share your answers in the comments and tell us which topic you would like to revise next in the UPSC Quick Revision series. Till then, keep watching Vision IAS.